I'm going to talk about what happens when arrested for a DUI in Washington State. Hello, I'm Reece Merrill with Merrill Law. Now, if you get arrested for a DUI in Washington State, there's two processes going on. One's the administrative process with your license, which would be governed by the DOL. The second process is governed by the courts and that determines any kind of criminal punishment aside from a license consequence, potentially going to jail, hopefully not. Now, with the process with the DOL will move much faster than the courts. The courts have 2 years to file any case against you as a result. The DOL will move much quicker, and you'll have 5 business days to request a hearing for the administrative process of suspending your license. If you get arrested for a DUI, it's very important to talk to an attorney about that DOL hearing fairly quickly and the strategy you want to take there, whether or not you want to request it or whether or not you want to get the restricted license. But we should still be able to help you keep driving some way. So for the court side, at some point within the 2 years from the date of the violation, the date you were arrested or had contact with law enforcement, they'll schedule your first court appearance, which is called the arraignment. At the arraignment, it's time to enter a plea. You'd want to be pleading not guilty at the arraignment. The court will also set some conditions of release. The basic conditions for a DUI the court will set at arraignment will be: don't commit any criminal law violations while the case is pending, don't drive without valid license and insurance, don't get another DUI. And depending on the jurisdictions, there might be an admission interlock requirement, and that's going to be more dependent on your individual criminal history, as well as the jurisdiction the case is in. At that arraignment date, they'll set pretrial hearings, which are just basically status hearings to let the court know if you're ready to resolve the case, you're ready to tell the court you're ready for trial and set for a trial date. Generally, at that first hearing, most people won't know whether or not they want to go to trial, so there'll probably be multiple court dates. After the court sets conditions, they're also going to set pretrial court dates at that first hearing, the arraignment. That pretrial hearing is for letting the court know the status of the case. Either we want to declare that we're ready for trial, we want to ask for more time to investigate and negotiate the case, or we have some kind of resolution that everybody can be happy with. It's possible that the case gets resolved at the first pretrial hearing, but it's also not outside the ordinary. There'd be multiple pretrial hearings. The reason for that is to give your attorney more time to investigate and negotiate the case. Potentially there's some affirmative conditions the state wants done before the case can resolve, and things of that nature. That's the basic outline of the process, both with DOL and with the court. Now, anytime you're arrested for DUI, it's important to get in touch with an attorney. You can get in touch with me at merrilllaw.com or call me 425-259-4972.